Okay, very good. So my name is Robert Mack. I've been appointed as the hearing examiner in this matter. The matter is an appeal by a number of parties of a mitigated determination of non-significance issued by the Port of Olympia under SCPA 25-01, signed by Mr. Gilbertson, who I think is in the meeting, dated March 6, 2025. We have some preliminary matters, which is, I suppose the first is, well, we can have notice of legal appearances. Mr. Pierce-Wright, you're representing the port, and Ms. Newman is representing the appellants. Mr. Griefen, is it Griefen or Griffin?
It's Griefen, like good grief, Mr. Examiner.
Okay.
I work for Claudia Newman and represent the appellants.
Right, but Ms. Newman's going to be the spokesperson for the appellants. Is that correct? Or are you going to be involved with stuff? You're going to share the duties?
We're each taking on different topics. So I'll be doing direct for some witnesses and Mr. Griefen will be doing direct for other witnesses.
Okay, you'll identify that at the time.
Yes.
There was a preliminary issue about
Mr. Hearing Examiner, if I could, with me is Kale Aniker from our office, also representing the port.
Okay. I think I saw, let me see.
Yes, I have a little,
Kalen.
Yep, there I am.
I've got you, Kalen Aniker. Okay, Aniker, thank you. Anyway, there's an issue about, I had not imposed rules of procedure while the motions are filed, and at the time the motions are filed and I ruled. I adopted them last week. There is a resolution of the Port Commission establishing their SEPA regulations that refer to hearings and the hearing examiner, and an adoption of, if the hearing examiner, I think, requests rules of general procedure, they are to be adopted by the port. I'm going to interpret that as I have not been appointed as a hearing examiner by the port for all hearings, and I don't really have the authority to request adoption of rules for future hearings. So I'm going to read that narrowly, and I think Mr. Pierce-Wright will, whether he agrees with me, he's not going to, I think he doesn't object, that I will proceed under the Tumwater rules and not require the commissioners to approve my adoption of the rules. Ms. Newman, I think last week you had concerns about that and wanted to think about whether you objected to that. So I don't know what your position today is, but I thought we should handle that first.
Right. I do not object to that.
Oh, okay, very good. I thought you might object, and then I was going to suggest we proceed, and it just becomes an appellate issue. I thank you for doing that, and I apologize for the lateness in adopting the rules. The rules are very broad. I don't think they're going to.
Yeah, I read it the same way that you did, Mr. Examiner.
Well, I didn't read it that way the first time, but
yeah,
the AG's office that said keep reading something to over and over till you get the result you wanted. So I think that works. So we will adopt those rules. I have two related matters. One is the scheduling of one of your expert witnesses, Ms. Newman, and then this week. So if we can proceed apace, I guess, this week, we can start at 9:30 and end at 4:30 unless the parties want to end at 4 or later. You had one witness, you said, who was not available this week.
correct.
And who is that?
That is Jim Matthew, our hydrogeologist. He submitted a report and we have a CV.
Do you know when he would be available? Do you have?
I'm sorry, I wasn't prepared to set a date.
Okay.
should have been, but I haven't asked him recently his availability, but I knew it was end of July. I can get that information from him during a break and
If you could please do that. We don't have to do it today, but
okay.
if the date works for Mr. Pierce Wright and Mr. Haneker, what we might do then, if we proceed well enough, is move one or two other witnesses to that day and maybe free up Friday this week. I don't know if that would help, if that would be agreeable to the lawyers, but rather than have your entire week taken up by this matter, at least that's what I'm thinking.
I'd prefer that myself.
Mr. Pierce Wright.
Yeah, I don't have a specific objection to that. I'd prefer it not to continue out too far.
Right.
We would endeavor to have the earliest possible date we can get
I
from
would
Mr. Matthew.
I'm trying to free up my August, so I'd rather it got completed this month. I want to thank the port for setting this up, the hearing by Teams, and Ms. Newman, I can't thank you enough for preparing the exhibit list. And I don't know if Mr. Pierce Wright has had an opportunity to review that list, and Mr. Haneker, but the one thing that may cause some issues for me, and you'll have to bear with me, is that if I accept the exhibit list and the numbers, which makes sense, I'm going to have to match them to the documents I've had filed by the lawyers with different exhibit numbers. And so I may stumble around trying to find the document if a witness is talking about it or you're talking about it.
I did try to match the numbers match the appellants numbers, so they're identical. Then I added the ports at the end, and so it's only, and there were a lot of duplicates. So the stumbling may happen from exhibit 66 or 63 to 71 is the only exhibits that may not match what you've already prepared.
Oh, I see what you've done. I generally admit exhibits at the beginning of a hearing rather than have witnesses establish a basis for admitting them. But most of the exhibits are appellants. I know the port has exhibits. Do either of you, and you're within your rights to say so, do either of you have any objection to any of these exhibits being admitted, or do you want additional time to decide whether you have objections to these exhibits being listed?
I have a couple of comments. One, if I could, just on preliminarily, and we can address this later, is that the entire 2021 master plan update is noted as Exhibit 1. I wonder if for purposes of making a clear record, it would help to separate the chapters into 1A, 1B, which we did for in our list. I'm not stringent about that. I just want to hope, my goal is to make a clear record.
I have the hard copy in front of me. Is it broken down by letters or by numbers? Is it like 1, 2, 3? I forgot. I think
The chapters are numbers, and there are numbered appendices.
Right. I can break those down by numbers. So like 1, 1, 1, 2, 1, 3.
That would be great.
I don't want to change that. It confuses me to have the number in the exhibit and then a letter in the exhibit list. So I'll make a note of that.
Mr. Examiner, this is Zach Griefen. I just note that the pagination in the master plan update is 1-1, page 2 is 1-2. That might become confusing. I'm intending to say Exhibit 1, Chapter 4, for instance, page 4-20.
Okay. Well, let me reserve how I'm going to break down Exhibit 1 the references. I've got it here somewhere. I've got to find it. Well, let's do this. Let's just call it Exhibit 1 and then refer to the page reference. I see that Section 2 is 2-1, 2-2, 2-3. So, Mr. Pierce, right, I realize that it's a huge document and you could give it different numbers, but let's just call the whole thing Exhibit 1, and then I can look at the page references and the sections when you direct me to them.
Okay. We do have several objections to categories of appellants exhibits, and I've tried to break them down into categories to make that easier to understand, because I think there are 5 different categories. And I don't want to take up too much preliminary time, but I thought it was appropriate to address that at the outset.
Okay, do you want to give me those now?
Yeah, the first category is commentary submitted by the appellants. There are 11 exhibits that appellants have submitted that are effectively argument. I don't think it would be appropriate to include those as evidence. I can identify the numbers for you.
Go ahead.
Exhibit 6, Exhibit 12, Exhibit 18, Exhibit 19, Exhibit 25, Exhibit 45, Exhibit 45B, Exhibit 46, Exhibit 47, Exhibit 48, Exhibit 49.
Okay. What's your second category?
Second category is documents from the 1990s and early 2000s. Appellants have submitted several newspaper articles from 1994 and 2000, as well as studies from the 90s. It's possible that an expert will substantiate those, but I think absent that, those exhibits are inappropriate and not germane to what's under appeal here. I can identify the numbers for you.
Please do.
Exhibit 7, Exhibit 8, Exhibit 13, Exhibit 14, Exhibit 15, Exhibit 38, Exhibit 39, and Exhibit 61.
Okay, very well. What's your other category?
There are a number of exhibits that deal with other properties or other transactions than the master plan update at issue here. There are 6 exhibits dealing with those other properties or transactions. I can identify them for you.
Okay, very good.
Exhibit 12, Exhibit 31, Exhibit 32, Exhibit 35, Exhibit 45A, and Exhibit 58.
58.
58, yeah.
It's 58. Let me look here.
'58 is an analysis from King County International Airport.
Oh, I see that. Okay, you have 2 more categories.
I have 2 more categories, shorter. One, exhibits that are not generally relevant. There are 2 of these. Exhibit 9 is a common interest agreement relating to the Habitat Conservation Plan. Exhibit 59 is a hydrology report evaluating parcels other than the parcels at issue in this appeal.
And your final category?
One is Exhibit 24 is an article written by a Como News intern. And Exhibit 34 is a report by Mr. Matthew that we're not objecting to the entirety of it, but he's a hydrologist, and at pages 9 to 13 provides opinions about impacts to protected species that appear to be outside the scope of his expertise.
I see. Well, given all these, I suppose what I can do is I don't want to recess in time for me to review all of these before we proceed, but I can admit all the other exhibits. Subject to admitting the rest of these or not admitting, depending on testimony that's provided or argument by Ms. Newman about their relevance. That's kind of I wouldn't say sloppy. It's going to be a little hard for me to track, but I don't know how else to do it. So is there any objection to me admitting all the other exhibits at this point and then suspending a decision on admitting the exhibits listed by Mr. Chris Wright?
No objection.
Okay, I may rely on the, I'll have to make a list during the first break on your master list of exhibits to indicate which ones I've admitted and which ones I haven't. I'm not going to take that time now to go down and tick down the list.
And
I can
Mr.
Pardon me?
For the record, this is the first we've heard any of this as far as objections to exhibits. So we have to have some time to digest this large amount of objections. We were not aware of these objections before now.
No, I understand that.
Yeah.
And just so the attorneys and the other people in the meeting are aware, I'm not going to say what a judge said once when he was delivered 3 boxes of materials the night before a 9 a.m. hearing, and he said he came in and said he had read all of them, which was clearly not true. I have read most of the primary documents that the parties are relying on. I have not read some of these exhibits I've not read or reviewed. I have looked at them, but the primary documents you're relying on, the checklist, the master plan update, some of the comments on that I have reviewed. The rest of these I haven't, and I may, if I've reviewed some of these and I think they're relevant at a later break or later in the hearing, I may admit them without argument. So right now, let's admit everything but the ones Mr. Pierce Wright has objected to. Could be a little awkward on testimony, I suppose, if someone's referring to one of these, but at that point, I guess I can decide whether it's relevant or not. The other point is some of them may be admissible, but as Mr. Pierce Wright says, they may, and either side may have this attitude, they may include opinions or matters that are not directly relevant or that I need to take notice of, but that doesn't mean the entire document won't be admitted as an exhibit, but I'll reserve ruling on those till later.
If I could raise one other issue.
Go ahead.
Question, I suppose. Exhibit 57 is an FAA advisory circular. Those were cited in the summary judgment materials, and I don't have any objection to you considering it or it being admitted. My understanding is that that would have been like a legal authority because it provides legal authority and isn't necessary as an exhibit. If you take the position that those types of authorities should be admitted as exhibits, then we would have others to introduce.
May I respond to that?
Go ahead, Ms. Newman.
I agree, that's a legal document. I put that in the record only because sometimes I think it's easier when there's something that's not easily accessible, that's legal, it's not code provisions or otherwise easily accessible. I thought it might be nice to have it as an exhibit. I have no problem not including that as an exhibit, and I would not by any means argue that other legal authorities should be exhibits, simply because that one is.
So you both can cite me to legal authorities and I guess government. I'm not applying the civil rules of evidence, but the government regulations or published materials that are, I forget what the rule is, are available to parties and have some legal authority. They don't have to be listed exhibits, and I can look at them. So so given that, I may I'll allow 57 in now. And Mr. Pierce, right, you may want to refer me to other, especially if you have a witness who wants to refer to it with regard to Federal Aviation Administration policies and directives. And Ms. Newman may object at that point, but if you have other ones that the witness talks about that you want admitted, I may very well admit them.
Okay, thank you.
My goal is to, I mean, it's a conflicting goal. It's to have everything in the record that's relevant for my decision, and if either party appeals, someone else to review. On the other hand, have matters that are actually relevant and pertinent to the matter and not going off on other tangents. So I don't know. It's a balancing act. By the way, I appreciate civility of the lawyers. I've had hearings where people aren't as civil with each other as me. Is there any other preliminary matter before we begin? I could allow opening statements if you want them. I don't know that I need them, but if you want them to direct me, it would be helpful. My ruling last week, I think, indicated the issues I want to focus on. And they include whether, and it's not a ruling, whether there were environmental, whether at this stage with this decision, certain environmental matters should have been considered, or whether this is a phased matter where they're to be considered, if at all, at a later date. And that relates to what information, if it's pertinent, was available at this time of the checklist. Now, that's not my ruling, but that's sort of where I'm going on consideration. I understand the argument of the port, and I understand the arguments of the appellants, but do either of you want to make an opening statement? I'd be fine if you did.
Can I cover just two more small preliminary
yeah,
procedural issues? I'm sorry, Mr. Examiner.
No, go ahead.
One curiosity for us, because it changes kind of what we're doing during the hearing. I'm curious to know if the port would agree. We would prefer to do written closing if possible, especially considering the phrasing of the issues by the examiner in the decision on the motions for summary judgment that we received on Friday. We have a lot to chew over and a lot to cover, and I would hope that we could do it through written closing rather than oral closing.
I have no problem with that.
Okay.
You don't have a problem with that?
Written closings would be fine with the port.
That'll be helpful to me. I mean, it's going to be, that'll be helpful to me. I just want to set reasonable deadlines for the closings. I don't think I need to have rebuttal from each of you to each person's closing, because their argument that I considered. And I know the parties, probably especially the port, would rather this matter be decided as soon as I can. I mean, not that the other parties don't want that, but so I'll set a reasonable schedule at the end of the hearing for those, and then for my decision. So thanks for raising that.
Thank you. And one small issue with standing, we're a little unclear on how to address standing at the hearing. We are thinking, do we need to resubmit all of the declarations during the hearing, or can we rely on those declarations? I don't really know where that standing, we were not planning on having all of our witnesses testify about standing.
The declarations are exhibits.
They're not exhibits. They were attached to the motion, response to a motion for summary judgment. Should we include them as exhibits at the hearing, or can we just rely on them?
Well, I don't want to muddy this issue. It's conceivable. I've decided, except for one, they've made a prima facie case that they have standing. Mr. Pierce,
Okay.
the port may want to contest that, and depending on the decision, the port may want that as an appealable issue. I'm just thinking. And in that case, they probably should be exhibits.
Okay.
I don't think you have to call them as witnesses, but I think the port can either do that, or they can argue without them testifying, just based on the declarations that they don't have they don't have a sufficient interest and should not have been granted standing.
Okay, we would appreciate some heads up. We were not planning on having any of them testify, so if the port could tell us offline whether they're wanting to, I guess, are you implying they could cross-examine them or?
Well, let's do it. I think there's enough in the record, but their declaration and then the extensive objections by the port, and I forget the document.
Okay.
Pointing out whether the person has a direct and cognizable interest in the matter. I think that's in the record.
Okay.
I suppose the port, if it wanted, could ask me to subpoena them to examine them on whether they have standing. I'd rather not do that. But the standing issue may be appealable on the part of the port that they should not have, and Black Hills Audubon should not have been granted standing. So I don't want to cut off that argument for them.
I guess my view is that the declarations are part of the record that would be subject to any appeal. You know,
Okay.
I'm not saying that that's what's going to happen, but I don't view that as necessary to enter those as the exhibits. And we're not going to be asking you to subpoena anyone.
Okay, I think that makes sense. That okay?
That resolves that for me then.
Okay, thank you. Thanks for raising it. Any other preliminary matter that I've overlooked? Do either of you want to make opening statements? Ms. Newman, did you want to make an opening statement?
I would like to.
Okay, go ahead.
Okay, good morning. My name is Claudia Newman and I represent the appellants in this case, challenging the Port of Olympia's decision to issue a mitigated determination of non-significance, or MDNS, I'll refer to it, for its airport master plan update. Now, let me start with something that has been obvious to me from day one. We should not even be here today. Everything we're about to walk through in this hearing, the impacts to water, wildlife, habitat, stormwater, and noise, these are exactly the kinds of issues that should have been addressed through a proper environmental review by the port before it issued its threshold determination. That's what SEPA requires for a long-range 20-year development plan with major environmental consequences. Indeed, SEPA requires an EIS, an environmental impact statement, for this type of major action. Agencies do this all the time. I'm not sure I've ever seen an agency fail to prepare an EIS for a non-project action of this magnitude before this one. That's the process the law sets up for a reason. If the port had engaged in an actual review of impacts, the appellants would be participating in that process instead of this appeal, engaging with an actual environmental analysis, submitting comments based on real data, talking about mitigation options, and helping shape the outcome before the decision was made to move forward with the preferred alternative for development of the airport. But that is not what happened. Instead of doing the environmental review that SEPA requires, the port issued an MDNS without conducting any environmental review at all. They didn't review the impacts and conclude they were insignificant. They skipped the review entirely, and their rationale, that this was a non-project action and therefore didn't have environmental impacts to evaluate. But here's the problem. In adopting the preferred alternative, the port committed to a very specific course of action. That alternative is not vague or aspirational. It's a detailed roadmap for future development over 200 acres of aviation industrial use, 54.5 acres for commercial air service, 48 acres for corporate general aviation, and much more. And yet the port expressly stated in their MDNS that they didn't analyze the impacts of adopting that plan. Not for stormwater, not for water quality, not for wildlife, not for noise, not for habitat, and the list goes on. Instead, they said that they will look at the environmental impacts later on a project-by-project basis as individual developments are proposed. But SEPA doesn't allow agencies to commit to a development plan now and defer environmental review until later. The law requires review before a decision is made at the earliest possible point in the planning process, so the assessment of impacts can inform the decision. When an agency chooses among specific alternatives, as the port did here, that is exactly the moment when SEPA requires a hard look at environmental consequences, because that's when the big picture gets locked in. They're choosing where industrial development should occur. They're choosing how many acres of the airport property should be dedicated to industrial development. They're choosing where taxiways should be located, and so on. And on a side note, I want to clarify that the adoption of the preferred alternative is not subject to FAA approval. The FAA approval argument being made by the port is a red herring argument. When an action requires FAA approval, it is exempt from SEPA review. It's completely exempt, no MD&S even required. And the two actions that require FAA approval are the airport forecast and the layout plan, which is Chapter 5. We are challenging the failure to conduct proper SEPA review of the preferred alternative, and the preferred alternative is not exempt from SEPA review. And one of the most serious flaws in the port's process is the fact that it results in evading any analysis of the combined impacts of all the different projects and development that will be allowed by the preferred alternative. And let me be clear about what I mean here. There's been some confusion in the briefing over what we mean by cumulative impacts. The traditional cumulative impact analysis is talking about the combined impacts of the proposed project with other projects off of the airport property. And in this case, for example, that would implicate development outside of the airport property, such as the New Market Industrial Campus, which is a separate project. And so you'll hear about that more in the testimony. But that's not what we meant when we used the phrase cumulative impacts in our briefing. With that, we mean the combined impacts of all the projects that make up the preferred alternative. SEPA prohibits piecemealing review of impacts. SEPA requires agencies to evaluate how impacts add up, not just one project at a time, but across the full landscape of what's being planned. That kind of analysis is critical at this stage when the port is designating entire areas for specific types of development. Because when you ignore the cumulative picture, you miss the total stormwater impact of everything combined. You miss the way drinking water supplies or aquifers might be affected, not by one building, but by everything together. You miss the total loss of habitat for species that are already on the brink, like the Olympia pocket gopher, when each new project chips away at what's left. These aren't speculative impacts. These are predictable, measurable, and meaningful. Right now, they are exactly the kinds of impacts that SEPA requires agencies to evaluate at the planning level. And while agencies can use phased review to evaluate some impacts now and others later, that is not what happened here. The port didn't conduct partial review, which is what happens with phased review now, and defer some details to later. They conducted no review at all. They never mentioned phase review. What they simply did was kick the can down the road. That is not legal, and that's not responsible planning. And this broken process has forced the appellants, citizens who care deeply about their community and their environment, to shoulder the cost of making sure this basic environmental review happens. So we're asking for something very basic from the examiner with this appeal. We're asking that you require the port to go back and do what the law requires, that they withdraw the MD&S and conduct just proper environmental review of the decision to adopt the preferred alternative. That's the minimum SEPA demands. And if you do agree with us that the record clearly shows that an EIS is warranted in this case, then we ask you, Mr. Examiner, to order the port to prepare an EIS for this action. With that, I thank you, Mr. Examiner, and we're ready to present our witnesses, unless the port would like to do an opening.
Well, I'm going to ask Mr. Pierce Wright to do that, and I normally don't do this, but I have a question for you, so I understand what you're saying in part. Is it, and I may be phrasing this wrong, is it your argument, regardless of whether there are later decision stages, either by the City of Tumwater for permits or state or federal agencies for reviews of certain impacts, that the checklist should have considered reasonably available environmental information that conceivably could be results of those later approvals, and knowable information at this stage.
Without a doubt, that is my position, and that is solid black letter SEPA law.
I'm not stating that's my ruling.
Okay, yeah, I'm sorry.
Yeah,
I'm reacting to the arguments, because, for example, a comprehensive plan may be adopted by a county, and they will consider full, the impacts of what their plan is, even though permits still have to, the fact that there may be things that are barriers to actual concrete development happening on the ground doesn't come into the picture. If your plan allows it and authorizes it, and if you're making a decision about where to put your industrial development and where to put your commercial development, you consider the impacts, because you might do 50 acres of industrial development instead of 100 acres of industrial development.
I understand that, and usually I don't
Okay.
ask questions, and I'm not taking sides, but a lot of the cases deal with general local governments, counties or cities or state agencies or federal agencies where there's where it's not a non-project action. It's or if it's a non-project a review, it relates to a project or projects that are going to require that those decisions by the agency that prepared the checklist. That's not this case. I'm not saying how I'm ruling or anything, but it becomes a little more difficult, I think, where you have a special district such as a port that doesn't issue its own permits. And anyway, I'm talking too much, but because I have reviewed some of the cases on the authority side, and I'm just trying to understand. I understand your arguments. I'm not saying.
Thank you, Mr. Examiner.
Not saying I agree with them at this point, but I understand.
I appreciate your questions.
Okay. Mr. Pierce Wright.
Yeah, thank you, Mr. Examiner. Chris Pierce Wright for the port. There's one issue at the core of this hearing, which is what is the scope of the proposal at issue in the Olympia Airport's 2021 master plan update. The party's briefing has presented wildly different theories about that scope. But at the hearing, only the Port of Olympia will present expert testimony about how airport master planning, including the port's master plan, operates. On that subject, you will hear about the port's current and proposed master plans, primarily from Chris Paolini, the airport's manager. Mr. Paolini will explain that the port's current and proposed master plans use the same basic framework. The master plan begins with an assessment of existing conditions in Chapter 1, what facilities are currently at the airport, including its runways, taxiways, and other improvements, who operates at the airport, including the general public, and essential service providers like medical airlift, state patrol, and the Department of Natural Resources, and importantly, the regulatory environment in which the airport operates. Those include restrictions and approvals required by the FAA, applicable zoning restrictions imposed by the City of Tumwater, nearby land use, and, of course, environmental concerns. From there, Mr. Paolini will explain that the master plan forecasts anticipated future use of the airport in Chapter 2. This chapter focuses on total aircraft operations at the airport and the total number of aircraft based at the airport. Mr. Paolini will explain that total operations and based aircraft are well below their recent peak in the mid-2000s. He will also explain that the forecast anticipates modest growth over the next 20 years, the planning horizon for the master plan update, at approximately 1% per year for aircraft operations. Finally, he will explain that the forecast must be approved by the FAA. And in fact, the proposed master plan update's forecast was approved by the FAA in 2021. Based on that forecast, Mr. Paolini will explain that a master plan looks at what changes are needed to accommodate anticipated decline, or in this case, modest growth to operations, all set out at Chapter 3. He will identify that the port's current facilities are sufficient for forecast operations, and so the port does not propose expanding its operations capacity. For instance, he will describe that the port's two runways, which have substantially greater capacity than currently used or forecasted to be used, and do not need to be expanded. He will also note, however, that the port's taxiways are oriented in a manner that does not meet current FAA design guidelines, principally by failing to intersect its runways at 90 degrees. Finally, the port reviews potential development of property within the bounds of the airport that would not conflict with the safe operation of runways and taxiways. Those areas consistent with underlying zoning prescribed by the City of Tumwater and include things like general aviation, commercial development, and industrial development. To account for each of these categories, Chapter 4 of the Master Plan Update considers a potential alternative airport layouts, ultimately reaching a conclusion called the preferred alternative. This preferred alternative is the airport layout plan. I'll say that again. The preferred alternative is the airport layout plan. That preferred alternative is translated directly into Chapter 5, which is the airport layout plan, and which must receive approval by the FAA. And I want to pause to underscore a second here. Appellants appropriately concede that any non-project action that is subject to and cannot be implemented without the approval of a federal agency is by definition not a non-project action. WAC 197.11.704 2 sub B sub 3. The non-project actions involve decisions on policies, plans, or programs. The adoption of any policy, plan, or program that will govern the development of a series of connected actions, comma, but not including any policy, plan, or program for which approval must be obtained from any federal agency prior to implementation. Chapter 4 identifies a preferred alternative. That preferred alternative is taken directly from Chapter 4 and placed in Chapter 5, Airport Layout Plan. That airport layout plan must receive FAA approval. There are two layers of FAA approval of airport development and the airport master plan update that Mr. Paolini will explain. The first is that the ALP itself must be reviewed and approved by the FAA. That approval, which is known as a conditional approval, occurred earlier this year. Second, because the FAA's approval is only conditional, it must also review and approve any particular project. That subsequent review has not occurred yet for any project that could move forward under the ALP. After hearing testimony from Mr. Paolini, you will hear from Sean Gilbertson, the port's environmental director and SEPA responsible official. Mr. Gilbertson's testimony will focus on two areas. First is the impact of protected species on airport property. Mr. Gilbertson will explain that the airport provides habitat to multiple species protected under state and federal law. He will outline that for years, the port and the City of Tumwater have been working to receive approval for a habitat conservation plan. That plan would serve to protect these species while allowing development within Tumwater's urban growth area, including the airport. Until that plan is approved, no development at the airport can occur. Second is the port's environmental review and threshold determination and mitigated determination of non-significance. As a preliminary matter, and as I just stressed, SEPA does not require review of plans for which federal approval is required prior to implementation. Here, that extends to the aviation forecast, the ALP, and because the preferred alternative is the ALP, the preferred alternative as well. Mr. Gilbertson will also explain that at this early stage of review, a full analysis of potential environmental impacts from development is not possible. Nonetheless, the port's MD&S accounted for the most likely impacts, principally potential impacts to protected species. Mr. Gilbertson will also explain that the port's MD&S required mitigation related to potential impacts that are reasonably foreseeable at this time. One, development cannot occur unless it complies with legal protections for listed species. Two, impervious surface must be minimized. 3, projects must comply with air quality requirements. 4, stormwater discharges during construction must be mitigated. And 5, waste material cannot be discharged to groundwater. Appellants, as you just heard, present a vastly different picture based on their speculation about potential impacts if the entirety of the airport's property is developed to its maximum extent. Notably, none of the people appellants will call to testify has expertise in the aviation industry or in aviation, or rather airport master planning. Because of that lack of subject matter familiarity, appellant's testimony will have material holes. One of those holes is based on what their claim is about what SEPA requires. Appellant's testimony will not address the mandatory FAA review of any plan or project before the master plan update can be implemented. Another hole is that appellants will claim that the master plan approves substantial development. Appellants will likely testify that as a result of the master plan update, the port will be developing hundreds of acres of property, including habitat for protected animal species. They will also claim that the master plan proposes to add commercial passenger service to the Olympia airport. Those claims cannot be reconciled with the version of the master plan that you will hear from about the port. To parse truth from hyperbole, it will be necessary and important to listen to the differences between appellant's testimony and the testimony provided by the port. As Mr. Paolini will explain, again, to approve additional development, including development appellants worry about, the port must further amend its layout plan and receive FAA approval of that amendment. In addition, the master plan does not propose to add commercial passenger service. That claim is a misreading of an appendix to the master plan update, which was completed after the update itself and analyzes the feasibility of introducing commercial service in the future. The port has clearly and explicitly stated that it is not proposing to provide that service. The Ports Commission will not be formally adopting the feasibility study. The port will reaffirm that position through this hearing. Again, the master plan update does not propose commercial service. Ultimately, appellants will present testimony about the potential environmental impact, again, if the Olympia airport property is built out to its maximum extent. But as Mr. Gilbertson's testimony will make clear, there is no dispute that the port did not analyze the potential impact of hundreds of acres of aviation and industrial development. That isn't the question here. The question is whether that analysis was required. Because that future development is speculative, and because the FAA must approve any such development before it occurs, the evidence presented by the port will make clear that there is only one answer to the ultimate question of whether the additional SEPA review that appellants are demanding is required, and the answer is no. The port undertook a proper review under SEPA, and we ask that the hearing examiner affirm its special determination.
Well, I appreciate all of that. I mean, it's very helpful. And I am interested in what your witnesses are going to testify on the issues you raised. So thank you. I think we can begin. And if this were not an appeal, I'd have the agency that prepared the document begin. But since it's an appeal, Ms. Newman, I think you go forward.
Thank you, Claudia, do you want me to jump in with our first witness?
Yes, thank you. Please do.
So,
Mr. Examiner, for the record.
Just wait for both parties. I have no objection to if you have two attorneys on representing each party to split up their presentations with witnesses. But as you all know, just one of you then can participate in objections or questioning of the witness. I don't want more than one attorney from each side doing that.
Understood, Mr. Examiner. Thank you.
Go ahead.
For the record, my name is Zachary Griefen. I'm with the law firm Bricklin Newman, and we represent the appellants in this matter. Our first witness will be Jana Wiley. I see that Jana Wiley has turned her camera on. Ms. Wiley, can you state your name for the record?
Jana Wiley.
And can you spell that?
Janawiley.
Thank you. And where do you live, Ms. Wiley?
But before we
77.
get in, could we swear her in?
Oh, I'm sorry. I forget. I'm sorry. Very good point. Ms. Wiley, could you please raise your right hand? Do you affirm that you will tell the truth and nothing but the truth in the matter before me?
Yes, I do.
Okay, go ahead. Thank you for reminding me. Go ahead.
Thank you. You were about to tell us where you live, Ms. Wiley.
Yes, 7740 Normandy Street Southeast,
And that's in Olympia?
Olympia 98501.
Thank you. And how long have you lived there?
24 and a half years.
Ms. Wiley, how far away from the airport is your home?
My home is about 2.5 miles east of the airport.
And did you submit a declaration in this case?
Yes, I did.
Thank you. Do you, where you live and play and work, do you currently experience noise from aircraft using the airport?
Yeah, it's there's times where there's more aircraft than others, but yes, there's low flying, small planes that fly overhead. There are jets that take off from the airport, and they're quite loud.
And what's your professional background, Ms. Wiley?
Okay, I'm currently a licensed registered nurse. I was critical care trained and worked for high capacity with the largest cardiothoracic team in the country that developed angioplasty and innovative cardiothoracic surgery techniques. But right now, I'm currently working as a RN acupuncturist.
Thank you. And are you familiar with the master plan update that's at issue in this case?
Yes, I am.
And are you familiar with the SEPA mitigated determination of non-significance, or MDNS, that's at issue in this case?
Yes, I am.
Are you concerned about air quality impacts from aircraft operations at the airport?
Yeah, a lot. I have a terminal lung condition that cannot get better. When I got COVID in March of 2020 while doing healthcare work, my lungs took a huge hit. I was out of work for 6 months. Could not stop coughing, couldn't perform any of my physical work, either at work or home.
And you said you have a terminal lung condition. What condition is that?
It's called hypersensitivity pneumonitis, or it's an interstitial lung disease. And it was diagnosed by my pulmonologist while I was recovering from COVID. It's a comorbidity, so to speak. He told me there was nothing to cure it, that it's immune system mediated, that it would just require medications, and it would require avoiding any kind of trigger that causes inflammation in my lungs. So yeah, and what happens for me is that I'm doing daily oxygen saturation levels more frequently when I have a cough or I am triggered. And I really learned that everything that causes my lungs to trigger, which is smoke, any kind of air pollution, pollen, cold air, even the COVID vaccine caused me to react. And I was out for 2 weeks, passing out, couldn't breathe, and had cardiac issues from just even the COVID vaccine.
Thank you for sharing that, Ms. Wiley.
Yeah.
In terms of your activities, things you like to do, how has your lung condition affected you?
Well, I live a completely different life now. I used to climb big mountains. That was my passion. Climbing Mount Rainier, climbing in the Himalayas, easy go up to 19, 20,000 feet. I used to ride and compete horses. I would work full time to support my hobbies and my activities. And I can't do these things anymore, any of the things that I've just mentioned here, because I'm often short of breath.
I'm sorry, and thank you. Would you say you are particularly vulnerable to the harmful effects of air pollution?
I would say so, yes, knowing what I know medically as a healthcare provider.
Did the Port of Olympia do any analysis of how air quality impacts from increased aircraft operations would or might affect people like you who are particularly vulnerable to air quality impacts?
No, and that's why I became involved in this.
Okay. Can you tell me what a temperature inversion or an air inversion is?
Yes, if you could exhibit 25, please.
Sure. Bear with me, Mr. Examiner. I'm going to share my screen.
So
Can
this
you
hasn't
see?
been, so this exhibit hasn't been admitted. Mr. Pierce Wright still has an objection. I think you can ask her about it, then we'll see at the end whether Mr. Pierce Wright still has an objection to it being admitted.
Okay, and are you, it's not actually showing on my screen. Is this exhibit 25
I
of
see it.
Olympia's? Okay. And Ms. Wiley, can you see that exhibit on the screen?
I can see it, yes.
Okay. Can you tell me in simple terms what an air inversion is?
Yeah, in simple terms, an air inversion is also called the temperature inversion, is when a layer of warm air kind of acts like a lid and traps colder air below it.
And is that shown in this exhibit 25?
Yes, it is. Yeah, and there's obviously nuances to its causative factors. I have to add that too.
Okay. And there's some statements and bullet points there on the right-hand side of the exhibit. Can you read the first bullet point?
Olympia has frequent temperature inversions.
And to your personal knowledge, is that true?
Yeah, I mean, I've experienced it here. It's been one of those things like, because under normal circumstances, warm air rises and takes pollutants with it, and the skies are clear, right? And under inversions, we get these hazy skies. So, for example, during wildfire season, during the winter when it's cold and everyone's burning residentially, everything gets trapped down at ground level, and at that low elevation, people are breathing whatever is trapped under the inversion.
Okay. And when pollution is trapped near the ground, does that make you take any action? Do you have to up meds or use a mask, or what do you do?
I have to wear a respirator, those 3M half mask particulate vapor gas cartridges on either side respirators when it's really bad here. Yeah, I mean, I have HEPA filters in my home. I have high filtration system on my HVAC system. I'm pretty much in my home, but if I want to go out and outside, get in my car and drive to work, I'm even wearing the 3M half mask respirator during these really bad inversion layer times.
Okay.
So, yeah.
And have you ever seen an air inversion? Can one see an air inversion?
You don't really see it from the ground. You just experience, or maybe you can smell it. You know, it's the sunset's going down. You see those strange sunsets. But in my past, when I was climbing, and know that I used to go up to Camp Muir every week because that was my personal workout, and oftentimes I would be leaving during the inversion time to go up to Camp Muir, and I'd be sitting there at Camp Muir at 10,000 feet in absolutely clear blue skies, warm air temperatures. No one's wearing jackets. We're all in t-shirts sitting there having, a hot tea or something, and looking at the inversion layer down below all around Mount Rainier. So I have seen it personally and experienced it on the ground myself.
Okay. Mr. Examiner, I move for the admission of Exhibit 25 that illustrates what Ms. Wiley was describing.
Mr. Examiner, this is Mr. Anaker, we're going to object to the admission of this exhibit on the basis that it is effectively an expert's exhibit, and Ms. Wiley is not qualified to give this particular testimony or speak on this exhibit.
May I respond, Mr. Examiner?
Briefly. Go ahead.
Ms. Wiley testified that she lives here. She's frequently observed and experienced inversions, and described to her personal knowledge what an inversion is, and that correlates to this exhibit.
Here's what
And Zach, could I add one thing too? anyone can look up the air quality index numbers during these times, and you can see that there's trapped pollution during these
Ms.
times.
Wiley, Ms. Wiley, you may have good comments, but I have to listen to the lawyers on the objection.
Okay, thank you.
So I'll tell you what I will do. I will admit this, but with the understanding that it was not prepared by Ms. Wiley. It's not offered as an expert view, and it illustrates what she was talking about in the testimony. So I can give it whatever weight I think is appropriate. So I'll admit it on that limited basis.
Thank you, Mr. Examiner. Ms. Wiley,
I understand the court's objection, so I'm admitting it on a limited basis. Which
Understood.
number again was this? 20?
this is exhibit number 25,
Yeah.
Mr. Examiner.
Very good. Go ahead.
Thank you. Ms. Wiley, did the Port of Olympia do any analysis of how air quality impacts from increased aircraft operations would interact with air inversions?
No, they did not.
Have you yourself done any research on how increased jet exhaust would impact you?
Yes, I'm really concerned in particular about ultrafine particles.
And what are they? What are ultrafine particles?
Ultrafine particles, or UFPs, are super small particles that are less than or equal to 0.0001 millimeters in size. They're small, so small that they easily enter into the lungs, my lungs, and then can pass through into the bloodstream and go up into the brain. They can go into the heart. They can go into placenta, actually, and other organs as well.
Thank you. Did the, you said you were familiar with the SEPA materials prepared by the port. Did the Port of Olympia discuss the impacts of ultrafine particles in its SEPA materials?
No, they did not. Ultrafine particles were not addressed in the SEPA materials.
And what other air pollutants, if any, are associated with jet exhaust and concern you?
Lead. There is no safe level of lead, and children in particular are especially vulnerable to lead poisoning.
Is there unleaded fuel available at the Port of Olympia Airport?
No, I have talked with Warren Hendrickson about this a couple of times. There is none available.
Did the Port of Olympia discuss the impacts of lead anywhere in its SEPA materials?
No, lead was not addressed at all in the SEPA materials.
And do small aircraft as well as jets emit ultrafine particles and lead?
Yes, they do.
Thank you. I have no further questions for Ms. Wiley. If Ms. Wiley, stay on camera. It may be that the court has some questions for you.
Mr. Aneker, were you handling this witness?
Yes, I am, Mr. Examiner.
Go ahead.
Hello, Ms. Wiley. You already heard from me very briefly before, but we'll go through a couple more things right now. First of all, I think you mentioned very briefly, but what is your professional background?
I am a licensed registered nurse, critical care trained, worked in high-end cardiology units, and also at this time currently, just given what my condition is, I am a licensed nurse registered nurse working as a licensed acupuncturist in private practice. Primarily, I receive physician referrals from Kaiser.
And what do you have a university degree?
Yes, well, I have a master's degree. I do not have a, let's see, no, that's, I could just leave it at that.
What is your master's degree in?
My master's degree is in science. I was pre-med twice.
Okay, and any specialty or just science?
Well, I was interested in all levels of science. I would call myself a nerd, also a researcher. I worked for Western Institutional Review Board too as well. As a nurse presenter, I worked with consent forms for major pharmaceutical companies and medical device firms for Western Institutional Review Board. So I would just call myself a science nerd in general. And some of my favorite reading material is science related. I do a lot of research for my clients right now too.
But there is no speciality like biology, nursing, anything like that on your degree?
No, it's science, and I have my degree in nursing.
Okay. And is that a bachelor's degree that you have in nursing?
No, it was an associate's degree. I was getting ready to go in and get my advanced practice nurse degree at University of California at San Francisco, but I changed course and went in and studied acupuncture in preparation for moving to Washington State. I decided that I wanted to have a little bit more free available time for myself, and I realized that I wouldn't have that in the profession I was heading into.
And from which institution did you receive your associate's degree?
It was the City College of San Francisco.
And your master's?
That was from the, well, I had to get a bachelor's degree in sciences to get admitted into the acupuncture school I went to, which was the American College of Traditional Chinese Medicine. And from there, the criteria in California for acupuncturists is significantly higher than it is here in Washington State. We were primary care providers for the state of California. So we had to have competency in Western pathophysiology, pharmacology, and understand the connections between those two fields of medicine intimately.
And your bachelor's degree is in classical Chinese medicine?
No, the bachelor's degree was in science. I had to have
right.
a BA level of science to get into the school to study acupuncture in California. It's a different level of expertise that's required in California. Here in Washington State, if you think of an acupuncturist, their amount of education is dramatically less. Their clinical supervised time is dramatically less. So yeah, I mean, I came from California. That was where all my higher education was.
Okay.
Through the University of California, Irvine, for example, when I was pre-med.
And what, I think you may have already mentioned this in your direct testimony, but what certificates do you have?
What certificates do I have? In what way do you mean?
Anything that, I suppose certificates or licenses would be.
Licenses. You have to be licensed to be a registered nurse. You have to be licensed to be an acupuncturist in the state of Washington.
Okay. And in your professional career, do you have any experience as an acoustical engineer?
An acoustical engineer? No, you cannot call me the noise specialist, but I've certainly looked at noise as a problem that impacts people's health.
But you're not specific.
No, but it comes up. I am a healthcare
expertise.
provider, and noise can be an issue for a lot of people.
Hold on, Ms. Wiley. Mr. Examiner, I'm going to raise an objection. We didn't seek to qualify Ms. Wiley as an acoustical engineer. I'm not sure where Mr. Pierce-Wright is going with this.
Well, I know she's not qualified as an expert on acoustical engineers, but she did testify about noises and various things. I think where he's going is as to how much weight I give her testimony about the matters she discussed. So I think he's free. I'm going to give him some leeway in asking the questions.
And this is Mr. Anaker, too.
Anaker.
I realize we're both on the same screen.
My apologies, Mr. Anaker.
Oh, that's fine. So have you, in your professional career, have you done any work in meteorology?
No, I haven't. But, as a sailor, I built and sailed my own wooden sailboat. I was to go around the world. And in my career as a mountaineer, we pay attention to the weather. We pay attention to the wind. Every climb is predicated on that. So no, I'm not a meteorologist, but do I track meteorology? You bet I do.
Not a climatologist either.
No, I'm not a climatologist.
Okay. What about an environmental epidemiologist?
No, I wouldn't call myself an environmental epidemiologist, but I can say that I've worked in healthcare in critical situations, and there are environmental impacts that impact people's health.
Okay. And do you have any expertise in aviation?
No, I don't.
And that includes aviation propulsion like airplane engines.
Correct. No, I have a lot of friends and family who are pilots, but I am not an aviation expert. My realm is healthcare and had been competing horses at high levels and climbing mountains.
Okay. And so this whole hearing is about the 2021 amended master plan update for the Olympia Airport, correct?
Correct.
And what is your understanding of what the master plan update actually accomplishes?
Well, I read about a lot of different proposals in there, and that's what prompted me to call Warren Hendrickson. I actually talked to Chris on the phone too a couple of times. And initially I was just concerned about, when are you getting unleaded gas, things of that nature. And then I saw this plan come up and it looked like there was considerations for potential increase of aviation operations. And meanwhile, I'd also noticed that there've been more helicopters and some a bit more flight training stuff going on there. I know there's an FAA certification station there and a couple different flight schools. I just questioned all of this, and I would say that conversations were polite and congenial. But then when I saw that there was proposals to potentially expand these operations, that's when I became concerned.
And do you think that the additional flights that you've been seeing recently are linked to the master plan update?
I don't know. I couldn't make that link.
And do you think that the net master plan update will necessarily lead to more traffic?
I cannot make that assumption, but I see that it's in the master plan update, that there is a proposal there to do so.
Okay. And just quickly, you testified on inversions. Do inversions only happen in Olympia?
No, and I think my testimony was clear that there were times that from Camp Muir, I could see inversions enveloping the whole area leading towards Olympia.
Are they more common in Olympia than in other places?
That I cannot say. That would not be my testimony that it's more common here. My concern is that it's a regional issue and that its impact should be looked at. As our population is aging, there's more people like me with cardiac and pulmonary conditions, and I see them all the time in my clinic, that inversion layers with increased aviation would also be a burden on them, especially if they lived near the airport.
And you testified on ultrafine particles, and you said that you did research on them. What kind of research did you do?
Well, that started a couple of years ago, and I was in 2020, I was looking for anything that could help reduce my burden or reduce lung inflammation. And the kind of research I did was looking at, say, for example, studies that were done here in the United States, studies done in Denmark, studies that the VA had done. And actually, so the VA is now giving benefits to veterans who have been exposed to aviation exhaust. Particulate matter. I am a research nerd, and I go down those rabbit holes and I look at things, and I have some idea what a good research study is because I have taken statistics and research methodology and worked in the realm of research. So I know when I can find some good research that it's insightful, it's impactful, and it's guidance for making decisions. So that's what I can say about my research.
But you have no specialized expertise in.
No, I can't call myself a researcher, but I have taken courses. Have you taken research methodology and worked in the field of research before?
Well,
I have.
I'm sorry. Mr. Anaker asks the questions and you answer them. You don't ask him questions, so go ahead.
Okay, okay.
And finally, you made a statement on, let's see, on the relative fuels used by small engine and larger aircraft, correct?
I think I answered a question regarding, are you talking about the one regarding lead content? Do small planes and jets emit lead and
Yes.
ultrafine particles? And I said, yes, they do. And that is true.
But you have no particular expertise in aircraft and what various aircraft engines.
No, I've
use
answered
for-
that question. I've answered that question, but it's regarding emissions. Do they emit those? Do those, the smaller planes and jets emit lead? Yes, they do, and ultrafine particles.
No
And
further
if- and it-
questions.
Yeah.
Okay, thank you. Mr. Griefen, do you have any rebuttal questions?
No redirect,
Okay.
Mr. Examiner. Thank you. And thank you, Ms. Wiley.
Well, Ms. Wiley, I
welcome.
have one question.
Sure.
Have you had a chance to review your declaration dated June 5 of this year that was filed with the appeal documents?
I have not. I've been in a situation where I'm a durable power of attorney for a very sick, mentally ill sister in Florida. So my time has been pretty consumed by that. I have not gone back over my old declaration.
Okay, okay.
You have a question?
I understand. I have sympathy for you. Well, I was wondering if you would have changed anything in the declaration, but if you haven't reviewed it, I don't need you to answer that question.
Okay, yeah.
Okay, very good. Thank you.
Thank you.
Thank you. Do the parties want to proceed, or do you want to take would a 10-minute break be helpful or a problem for you? Or would you rather just go ahead until noon?
A short break would be welcome, Mr. Examiner, unless anybody else objects. I'll be working with our next witness, who will be Adam Jenkins.
Mr. Haniker, Mr. Pierce-Wright, is that okay with you?
That's fine with us. Thank you.
Okay, thank you. So for teams, I stay on. I just stop the video and the mic. Is that correct?
That's right.
Okay, very good. Thank you.
Mr. Examiner, we're back on at 11.
Yes, please.
Okay, thank you.
Thank you. Thanks, everyone. We're back on.
Thank you, Mr. Examiner. I can't see everybody's pictures, but I'm looking for Adam Jenkins. Adam, if you could turn your camera on and your microphone on and let us know that you're available.
I can't see.
I think he's on the second page and tried to talk, but I could not hear him.
Let me try a different microphone. Can you hear me?
Adam, we can hear you now, and I see you by
Excellent.
going to the second page there.
Very good.
Okay, let me, before you call in, go ahead.
Thank you, Mr. Examiner. Good morning, Adam. Thank you for being present today.
Good morning. Thank you for the invitation.
Can you state and spell your name for the record, please?
Yes, my name is Adam Jenkins, spelled ADAMJENKINS.
Thank you. And can you tell us a little bit about your professional background and your training and experience?
Yes, I'm one of the vice presidents at the Greenbush Group. Our office is 1448 Elliott Avenue West in Seattle, Washington, 98119. And I've been with the Greenbush Group for about 20 years, and I oversee the acoustical department. And in my time at Greenbush, I've had an emphasis on participating in projects with environmental noise issues, not only as an expert witness, but also as an engineering consultant. I have a bachelor's of science degrees in electrical engineering and physics and a master's of engineering degree in acoustics from Penn State. I'm a licensed professional engineer in 5 states. One of those is Washington State. And the expert witness testimony experience I mentioned previously has been for many cases throughout the Pacific Northwest related to environmental noise. And as a consultant, I've worked on dozens of aviation-related projects, including how military, commercial, and general aviation operations affect residential properties.
Thank you. And did you submit a letter report in this case?
I did. I submitted a letter report
Wait,
dated
before
June.
we go further, I forgot to swear him in.
Oh, thank you.
I'm sorry. Mr. Jenkins, very good. That was my fault. Do you affirm that you will tell the truth and nothing but the truth in the matter before me?
I do, Mr. Examiner.
I don't know if you have to re-ask the question since he wasn't under oath before. That's my fault for not remembering.
Thank you, Mr. Examiner. I'll take the experience he described is set out in Exhibit 56. That is his report, and it attaches his curriculum vitae, and we'll take that as read. If the port's attorneys have questions about Mr. Jenkins's professional qualifications, they can ask them. And
So
I think
that's Exhibit 56?
yes, Mr. Examiner.
Okay, I've got to find it. What's it attached to earlier? Do you know?
It was submitted as an exhibit with our exhibit list. I don't believe it was attached to a motion, although I could be wrong about that. When the parties, I'm sorry, somebody else is talking and I can't tell who or what they're saying.
Right. I'm looking for it in your declarations.
It's not a declaration, Mr. Examiner. It's an exhibit. It's exhibit number 56.
I know the number. I'm trying to find it in the earlier listings. Is it attached to any of the exhibits? The declarations by Claudia Newman? I'm looking here.
I don't believe so, Mr. Examiner. After the well, it's possible. Let me check.
I'm sorry, I just need to know.
I think it was just submitted along with our other expert reports
We
together with
submitted exhibits in a ShareLink file, Mr. Examiner. It was a ShareLink file provided to the examiner, I believe, last week, not with the motion practice, but a separate ShareLink file that was prepared for the presentation and sharing of exhibits. I can't remember the date.
Well, go ahead. I'll struggle to find it. I'm sure I have it, but go ahead.
Thank you, Mr. Examiner. And there should be a combined exhibit list and a link to all exhibits. And I have 71 combined exhibits on that master exhibit list, and a folder of those 71 exhibits. And this is exhibit 5656.
Okay, go ahead. I'm sorry to interrupt you.
And Mr. Examiner, if you like, over lunch, we could resend that link to download the 71 exhibits and the exhibit list.
I'm sure I have it. I don't have my assistant here to kind of guide me, but go ahead.
Thank you. Mr. Jenkins, you submitted your curriculum vitae together with your letter report?
Yes, I did. And to the extent that it's helpful, I can reaffirm that all statements that I said prior to being sworn in were true and accurate in the event that that's helpful to the examiner or to the port counsel.
Thank you very much. What documents did you review in preparing the report that was submitted as Exhibit 56? And I don't believe there was any objection to Exhibit 56, so it's in the record.
My review focused on the draft master plan update, which is Exhibit 1. The determination, the mitigated determination of non-significance, which is Exhibit 2, and the SEPA checklist, which is filed as Exhibit 3.
And since submitting your report, which was designated Exhibit 56, have you reviewed any additional information?
I have taken a closer look at Appendix 4-1 in Exhibit 1, which is the draft master plan update since issuing my report, specifically on the forecasted commercial aircraft operations.
Thank you. What, in reviewing the draft master plan update and the mitigated determination of non-significance and the SEPA checklist and this Appendix 4-1, what sort of a noise analysis did you find that the port prepared?
Very little in terms of a noise analysis. The draft master plan update, Exhibit 1, for example, summarizes noise effect thresholds based on FAA policy. That's on page 1-42, section 1.6.5 in Exhibit 1. And that section then goes on to say that the airport is unlikely to present a significant noise impact to the surrounding land use. And the documentation essentially defers any noise analysis for any of the proposed projects, even in the preferred alternative, to later study. And some of these examples are listed in Exhibit 1. Mr. Griefen, would it be possible to pull up Exhibit 1, specifically page 4-38?
I am endeavoring to do that, and there we go. Let's see if you are looking at Exhibit 1, section 1.6.5.
That was the first reference. I think that would be good to start there. Page 1-42 in section.
Yep. Are you looking at that on the screen now?
That's interesting. Yes. Yes, here we go.
Okay.
So this paragraph summarizes one element of the FAA noise policy. It's not a complete summary of it, but it does reference FAA Order 1050.1F that refers to a noise effect threshold of increasing the day-night level, which is a annual average sound metric commonly used to study airport noise emissions. It talks about thresholds for analyzing potential noise effects from operations. If we go then to page 4-38 of the same exhibit, we can look at some of the proposed projects
sorry. That would be chapter 4. Bear with me as I navigate technology and get to chapter 4.
While you do that, I'm going to close one door. I'll be right back.
Sure, thank you.
Okay, I've returned.
Okay, can you tell me if you're looking at page 438?
Right. So this is the section that talks about the preferred alternative and some of the proposed projects that are discussed in this section, including modifying existing taxiways, addition of a new landing area. There's also discussion of commercial development. This is on page 4-40.
All right, so we scrolling through, you discussed runways. I'm now on page 439 of Exhibit 1. Exhibit 1, Chapter 4, page 439, and then you were just discussing page 440, which we're now on.
Is continuing the list of projects in the preferred alternative, including development of areas at the existing airport for commercial use, in addition to aviation-related industrial development. There isn't a whole lot of information about what may occur in these areas of the airport, but it's a substantial amount of area, over 200 acres, that is planned for development to support aviation operations of an industrial nature. And then the bullet below is the commercial air service development, which is approximately 55 acres. And as I understand it, this is development to support the addition of commercial operations at the airport, which is discussed elsewhere in the master plan update, which we will get to.
Okay, and you were referring to a section on page chapter 1, page 142. Can you read the quote again that you mentioned? I think I may have talked over you when I was getting my technology fixed.
Yes, let me pull up that section so that I can read it.
I think the quote started, "The airport is unlikely."
Right, I'm just pulling that up. So it's the last sentence on the paragraph in 1.6.5, which is on page 1-42. It reads, future development at the airport is unlikely to present a significant noise impact to surrounding land use based on the current 65 DNL noise contour, providing that compatible land use in the future is maintained by the City of Tumwater.
And was there an accounting of these various categories of industrial of development that you went through in that statement about noise being unlikely?
Well, that statement about noise being unlikely in reference to the 65 DNL contour is only related to aircraft operations, which includes takeoff, landing, and taxiing. The FAA noise policy that would fall under that DNL threshold evaluation for potential environmental noise effects does not include many of the projects that we just listed and looked at in the preferred alternative. It doesn't address or include noise from commercial development. It doesn't address or include noise from industrial development or any sort of commercial development to the airport to support the addition of commercial service. It's only focused on takeoffs, landings, and taxiing. So to the extent that's one item in the list that we just went through in the preferred alternative, yes.
Do you have concerns about the lack of noise analysis? And if so, what are they?
Yes, I'm concerned that the Port of Olympia did not have sufficient information available for their review prior to issuing the MD&S. As one example, noise criteria for assessing effects from the commercial and industrial development of areas on the airport property are not stated, nor the potential effects discussed. As an example, the noise effects from commercial air service are not addressed in the master plan update. And another concern that I have is that cumulative effects from the proposed development projects in the preferred alternative are not discussed or studied. One primary issue with this is that the overall noise from all projects, this could include changes in aircraft operations and all other noise generated at the airport in the expanded and industrial development areas, won't be able to be addressed in a cumulative sense in the future when the projects are analyzed on a case-by-case basis. The master plan update is the best time and perhaps the only time for those cumulative effects to be reviewed. As within the scope of a specific project review, they simply won't, it will fall outside the scope of that project review to look at cumulative effects from other projects that would happen in the future.
Thank you. We'll
Another
get into the
issue is,
cumulative effects in a little bit. I wanted to ask you about the SEPA checklist.
yes,
That's in the record as exhibit 3.
yes.
And I apologize. Sometimes when I hit share, it shows me the PDFs that I have open, and sometimes it doesn't. I'm much more used to Zoom than Teams.
Well, you're more capable than I am, so you're,
Well, I appreciate your patience, Mr. Examiner.
it's my ignorance of how to operate these things.
Instead of showing this on the screen, Mr. Jenkins, I'm going to ask you to read from it. Do you have your own copies?
Yes, I do. And I'm making sure I'm on the right one.
So this is I am
Yes.
looking at Exhibit 3, which is the SEPA environmental checklist for the master plan update at PDF page 19 of 38. This is the SEPA checklist question that involves noise.
Yes, I'm there.
Okay, what does that state in relevant part?
So there are 3 questions in this part of the SEPA checklist that address noise. The first question talks about noise in the area that might affect the project, which there wasn't stated to be any. The second question asks what types and levels of noise would be created by or associated with the project on a short-term basis, indicate what hours noise would come from the site. And the response is adoption of the airport master plan update will not by itself result in the creation of new noise levels. The potential for noise-related environmental impacts associated with future construction projects included in the airport master plan update will be evaluated on a case-by-case basis at the time such projects are proposed.
And is there a problem with that or not? And if so, what is it?
Yes, continuing on with what we were discussing earlier, this doesn't allow for review of cumulative noise effects. If each project is studied individually on a case-by-case basis at some point in the future, the overall noise emissions from the airport in a cumulative sense would not be studied. If, for example, commercial operations are identified or analyzed specifically, that would not include other development projects such as the industrial development or other commercial development on site. There won't be an opportunity to look at those cumulative effects. Another issue with looking at these projects independently and likely sequentially is that existing ambient conditions affects noise analysis. This is a part of FAA policy, which was referenced in the section of the master plan that we reviewed moments ago. And it's also standard practice in environmental noise analysis from any other sort of operations that or activities, I should say, that take place at the airport that aren't technically aircraft operations. And if each project is done separately, the first project may be expected to increase the existing ambient noise environment by a certain decibel level, and then time passes, and that new level becomes the ambient for the next project. And the effects of increasing ambient and effects on the environment end up compounding, which is one of the major values of conducting a cumulative noise analysis, to be able to ensure that the individual projects over time don't compound into a much more severe impact than what they would present individually.
Is it fair to say that what you're describing is each project setting a new baseline against which the subsequent project is then judged?
Yes, that's
Kind of
typically
like
what happens when there are multiple sequential development projects at an airport. That's correct.
And at what point should an agency assess the total increases in ambient from all the projects together?
At this phase, at the master plan phase, when the projects have been identified and there's enough information to, at least in a preliminary sense, analyze those cumulative noise effects. This is really the only opportunity, in my experience, to be able to perform that analysis.
Thank you. And does this, well, we're on Exhibit 3, which is the SEPA environmental checklist. Is there another section that discusses noise and the production of noise?
Yes, if we continue 10 pages forward to PDF page 29.
And I'm not even going to attempt to share my screen. I've tried multiple times, and I'll try to work it out over the lunch break. But we're at Exhibit 3, PDF page 29. Go ahead, Mr. Jenkins. This is printed page 28. I also see that there's what looks like Baton's numberings at the bottom of the page that says 029. What does that state there, Mr. Jenkins?
Just one moment. Actually, do you mind if we sorry, just I myself might have my documents a little mixed up here.
And Mr. Jenkins, I understand that it was my task to put exhibits up on the screen, not your task. And I apologize for my inability to do so. I just can't seem to do so through the share button.
Understood. And
which document are, I'm sorry, which document are you referring to now?
We are on Exhibit 3. That's the master plan SEPA environmental checklist.
Okay.
And we're on.
Okay.
I have the hard copy in front of me if you want.
Okay.
Okay.
So we're on printed page 28. It says P28 in the lower right-hand corner. And at the top of the page, there's an underlined 3 words that say production of noise.
Mr. Griefen, I'm sorry, I didn't mean to interrupt. Go ahead, Mr. Herring.
Well, I have it in front of me. It's more important whether you have it in front of me, I guess, on the questions.
I realized why I wasn't able to find what I was looking for, and it appears that the attachment, the supplemental sheet for non-project actions, there's a little bit different page numbering. So the section that I'd like to refer to is actually in section D, the supplement sheet for non-project actions, which may have a different page number in the official exhibit. Let me see.
You can go ahead and read from it.
Can I just share my screen? I have it in front of me. I'm happy to share my screen, but it's in section D, the supplemental sheet for non-project actions. And it says that new aviation related and industrial development may result in increased noise levels from industrial activities. All development associated with future projects included in the airport master plan update will be required to comply with national ambient air quality standards for the approved zoning designation in which they are located.
And do you have any concerns about that?
I do. Of particular concern is the reference to the NAA standards, which do not include any noise regulations. So it shows a lack of understanding to what sort of noise criteria the project evaluation would be required to follow. FAA regulations would apply to aircraft operations and taxiing, but would not cover other commercial or industrial development at the airport, which I mentioned previously. Therefore, the criteria and methods to assess noise effects from the proposed development project in the preferred alternative are simply not addressed. And I'd be happy to walk through some of those specific development areas shown in the preferred alternative, if that would be helpful.
Yes, please. And you can refer to the exhibit number, chapter number, and page number, and then let's give it everybody a moment to get where you are before you dive in.
This is Exhibit 1, Figure 4-9.
So that would be
This is the
chapter
master
4.
plan update. It's the preferred alternative that shows the proposed development projects.
All right, so I am in Exhibit 1, Chapter 4, page 4-42, and it says at the top, Figure 4-9, preferred alternative. Is that what you're looking at, Mr. Jenkins?
It is printed page 4-42, Figure 4-9, preferred alternative.
Thank you. And Mr. Examiner, I believe many of the witnesses will be coming back to this Figure 4-9 preferred alternative.
Okay, I'm going to turn to my pre-electronic age. I have a hard copy in front of me.
That is clearly wise, Mr. Examiner.
Well, I don't know if it's wise. It's necessary for me. So, but there are a lot of attached diagrams. I'm trying to find it without page numbers. So I'm trying to find the page.
So do you have the master plan update organized by chapters?
Yes, I have it sequentially.
All right, we're in chapter 4, and this
Right.
is page 442. It's a full page figure.
Oh, I've got it. I've got it. I see the number. Okay, I've got it in front of me.
Thank you. Mr. Jenkins, what would you like to tell us about figure 4-9?
So I reviewed this figure by overlaying the city zoning map to get an understanding of where residential use is currently present and planned for it, just based on land use zoning. And what I found concerned me is the aviation-related industrial development area, which is the large gray area that shows 110.5 acres located above the airport. This plan north is not true north. So it's above the airport, but it's actually east of the main runway 1735. And there's residential property within 1,000 feet of this aviation-related industrial area. So I'm concerned about the potential noise effects of what's going to happen in that area of the airport and how it might affect those residential uses nearby. If you follow down to the right on the page, which are now at the southeast corner of runway 1735, we see another 31 acres of aviation-related industrial development, which is approximately 1,000 feet west of that same residentially zoned area. So similar concern here that we don't know what's going to happen here as far as activities that may generate noise that aren't aircraft takeoffs, landings, and taxiing. What sort of activities might occur in these properties and how might they affect the nearby environment? It simply wasn't studied in the master plan update. Another concern that I have is going to the west side of runway 1735. You'll see another aviation-related industrial improvement area. It's 34.2 acres, just below on the page, below the general aviation corporate development area. And this is immediately adjacent to residentially zoned property. So there isn't even a buffer here. So I'm also concerned about how noise generated in this development area may affect residential receptors in proximity to it.
And again, did the master plan update or the SEPA materials analyze or assess the potential for those impacts?
I was unable to find anything in the master plan update or the SEPA documentation that even addressed that noise emissions from those development areas would need to be analyzed, let alone a criteria by which would be assessed and what sort of mitigation measures might be available in the future to mitigate any noise impacts. So I found nothing.
Thank you. Let's go back to your report, which was admitted as Exhibit 56. And I'm getting there as well. Walk us through this a little bit. Your report discusses commercial air service. Can you tell us where it discusses that and what it says?
Yes. So on page 3 of my report, the third full paragraph, the last sentence reads, in addition, there's insufficient information in Chapter 2, which is the aviation forecast, which is just for general aviation operations, of the master plan update to generate updated contours for projections of future aircraft operations out to the year 2040, since the change in aircraft mix does not appear to have been studied. So that aviation forecast focuses only on general aviation operations. It doesn't address the commercial operations. The commercial operations are investigated in the feasibility study, which is Appendix 4-1 of the master plan update, which is a change to aircraft operations since there is no existing commercial service at the airport. And this is stated in Exhibit 1, page 1-25 in section 1.4.3.3. And I quote, commercial service is not currently operating at OLM. So any addition of commercial service would be a new addition to the facility. And if we want to, if people can turn to Exhibit 1, Appendix 4-1, I can walk through some of the high-level summary forecasts for the commercial operations that are included in the master plan update.
Please do, and give us a moment to get to the page before you discuss it. So we're in Exhibit 1, master plan update. It has a number of appendices, and this is Appendix 4-1, called Part 139 Feasibility Study, or Commercial Passenger Service Feasibility Study.
Yes, and in that feasibility study, turning to printed page number 12, there are two tables, Table 4-8 and Table 4-9.
Give me a moment to get there. Okay, I'm there. Table 4-8 in Appendix 4-1.
Thank you. So there are two types of commercial service that are investigated in this feasibility study as a part of the master plan update. And one of them is commercial satellite service, essentially relieving those operations from Western US hubs that they've been identified to be 4 airports: Los Angeles International, McCarran International, San Francisco International, and Portland International, which are listed in Table 4-8. The second type of commercial service are actual point-to-point regional service, which wouldn't be hub relief. That's actually new trips between the airports. And I will discuss those second. The first, which is the commercial satellite service, is shown in Table 4-8 and 4-9. And you see that forecasted commercial operation starting in 2035, which is about 10 years in the future. And if you total up all the annual operations in Table 4-8 and Table 4-9, which summarize those satellite service operations, you get 8,200 operations that would be new to the airport starting in 2035. That's 8,200.
Let me interrupt you for a moment. I'm having trouble finding the table in my printed copy of the master plan update. Are the
I
tables?
can help. I can
Are
help
they-
with that, Mr. Examiner. So first we want to find Appendix 4-1.
Oh, it's sorry.
I think it's important to be able to look at what Mr. Jenkins is
Okay, well, I have
discussing.
a-
So it's
So I have a page 9 with table 4.4 and 4.5. Is that it?
what does the page number on the bottom say? It just says
Says-
page 9.
It says 9, and then there are 2 tables.
So hold on,
That's
I'm
what
getting
the-
there.
I think that's what the witness is testifying about.
I'm
That
looking.
is the exhibit, although it's a few pages behind. If you page forward, Mr. Examiner, to printed page 12, you should see tables 4-8 and 4-9.
Well, there you are. Thank you. Got it.
Thank you, Mr.
So there's
Jenkins.
So there's a lot of zeros in those tables, but if you look at the 2035 and 2040 columns, those show the forecasted operations for the airport from this commercial satellite service, the first category of commercial service that I'm reviewing. So if you total up all those values, for example, in table 4-8, it shows 1,500 annual operations from LAX, LAS, SFO, and PDX. Total those together, it's 6,000. If we add that number to the 2,200 shown in table 4-9, it's 8,200. So that's where I'm getting the numbers that I'm presenting. It's 8,200 overall new satellite service commercial operations per year starting in 2035. And in 2040, it goes up to 21,300 overall annual operations from the commercial satellite service.
And do new commercial operations have a potential to create new noise impacts?
Yes, and this is one thing that wasn't studied or wasn't shown in the master plan update, or even this appendix that we're looking at is how that would affect vehicle mix, aircraft mix at the airport. Commercial service from these types of carriers serving these other airports would be different than the aircraft that are operating at the airport now. But what that mix might look like just isn't studied. So there are no conclusions that are drawn from this appendix about how it might affect operations in the future, particularly as far as noise emissions go. But adding commercial service is going to change flight tracks to and from the airport. It's going to present different aircraft than what are operating there now. And it will change not only the size of the DNL contour, but also the shape, which nearby properties experience more noise than others. These are all things that would change, and that's analysis simply isn't addressed in the master plan update or the SEPA documentation.
And do you want to discuss another table further on in this document?
Yes, there's a substantial more amount of commercial operations in the feasibility study. If we turn to printed page 17, so Mr. Examiner, if you flip through another 5 pages, you should find yourself on printed page 17 with table 4-12.
That I can navigate. I'm there. Thank you.
Okay, fantastic. This shows even larger numbers, and these are those regional point-to-point service from the operations that would occur at the Olympia Airport, both again in 2035 and 2040. Looking at the annual operations for 2035, it's 134,700. In 2040, it's 153,700. The air traffic control tower clocked 64,816 annual operations in 2020 for Olympia Airport. So this forecasted level of commercial service is 220% increase over existing general aviation operations looking at the 2035 year. And this doesn't account for the increase in GA operations that are forecasted in the master plan update. This is simply looking at the feasibility studies forecast for 2035 commercial operations against what the tower clocked in 2020. So
Thank you.
these are
Go ahead.
substantial increases. And those numbers are, if we take the satellite service tables we looked at and combine them with this table 4-1, those are the big numbers that we get. 142,900 new commercial operations per year in 2035 and 175,000 new commercial operations in 2040. And those are give you the 220% and 270% increase.
Could even a fraction of that large increase have significant noise impacts?
Oh, certainly.
And what does
even if it was just general aviation operations and they weren't commercial grade aircraft, simply that amount of increase from GA operations would be substantial in terms of a noise increase.
Okay, thank you. And what does the SEPA checklist say about projected changes to noise contours and operations?
Well, if we flip over to the SEPA checklist, which is Exhibit 3, page 29. This is PDF page 29, printed page 28 in Exhibit 3.
Okay, I'm there. This is, can you read the underlined words at the top of the two paragraphs?
Just a second. I might have this again mixed up with the no action documentation. Let me check this real quick. I want to make sure that I give the hearing examiner the correct reference here.
Yes, please.
This is also in the supplemental sheet for non-project actions. So in that supplemental sheet on printed page 29, the underline is noise. And the section starts, temporary short-term increases in noise due to future construction activities are not expected to be, etc. And the excerpt that I believe is very important to notice is that second paragraph in this noise section in the supplemental project non-action sheet is that the statement is the projected increase in operations at the airport through the 20-year planning period has only a minimal effect on noise contours, which just does not account for the addition of commercial service. It can't.
Okay. How could they have drawn, and let's go back to the previous page, which is PDF page 29 of the supplemental sheet for non-project action, printed page number 28. Do you see a heading that says production of noise there?
Yes, I'm there.
What does the third of the three paragraphs under that heading say?
Noise levels associated with future projects included in the master plan update relating to airplane operations can expect to increase with commensurate projected increases in air traffic.
Okay. And the quote you previously read on the next page was that the projected increase in operations at the airport through the 20-year planning period has only a minimal effect on the noise contours. Is that right?
Correct.
How do you think they drew that conclusion?
I don't know. because there was no noise analysis that was done, that the contours were not updated. I do not know how that conclusion was drawn. It doesn't line up for me.
And is it only the overall level of noise, of change in noise levels that's concerning to, say, a residential property?
No, it's not just the overall level. While that's usually the first thing that people will think about, it also has to do with the different flight tracks that the various aircraft will follow, which will vary depending on where the aircraft were coming from and the type of aircraft and conditions for the day. But the shape, if you will, of the DNL contours, that day and night level annual average noise contour that is used by the FAA to assess noise effects, those contours, the shapes change based on the different flight tracks. So when commercial service is added in 2035, not only will the size of the contour and the level change, but the shape also will. So, for example, residences that maybe don't hear the aircraft very often now may hear it more often. It really depends on how those flight tracks are determined as that commercial service is implemented at the airport. But it's not only the level, but it's also the shape of the contour. In addition to time of day, you might get flights arriving or departing at different times of day that you do now at the airport. Those are all factors that could affect the community response to the addition of commercial service.
Thank you. And I want to ask you just a couple questions about DNL and what does that mean? So is that an average of day and night levels over the course of a year?
So the day-night level is an annual metric that describes average noise levels, if you will, but the nighttime sound levels are penalized by 10 decibels. So any operations between 10 p.m. and 7 a.m. are effectively increased by 10 to try to account for increased noise sensitivity during nighttime hours at residential uses. But the DNL is a full year average. You don't hear a DNL. You don't walk outside your house and hear a 65 DNL. You hear the airplane flying over your head. It's used as a planning tool for projecting noise from changes in airport operations.
So you said you hear the aircraft flying over your head. If you had 6 months of aircraft flying over your head all the time and 6 months of no aircraft flying over, how would that be reflected in the DNL?
It would be averaged out over the year. So the overall annual number would be lower than what the first 6 months was.
Okay. Thank you. I don't have any further questions for you on direct. It may be that the attorneys for the port have some cross-examinations questions for you, or the examiner himself may have some questions for you.
Well, before I ask the port lawyers, I need to have some clarification because I'm a little confused, Mr. Jenkins. So when you, if you don't mind, when you referred to table 4.12, which has, trying to find it now. I had it in front of me at one point. The number, you had a calculation of 220% increase, but the numbers that you calculated the increase from, at least in my page, didn't, unless my note taking's bad, didn't seem to be the numbers on the page. Could you just clarify again which background numbers you're using and then which increase numbers you're using?
Yes, Mr. Examiner, I appreciate the question because it's not disclosed on itself. You have to add numbers of the various tables together. So if you were talking about just the total number of new commercial operations at the airport,
For
if you take
2030?
For 2035,
Okay.
we have to look at 3 tables. We have to look at tables 4-8, 4-9, and 4-12.
So your calculation comes from those.
Yes. If you add up all the annual operations in each of those tables together, you will get 142,900 for 2035 and 175,000 for 2040.
And again, that's tables 4, 8, 4, 9, and which one?
And 412.
Okay. Thank you. I'm sorry. I just had trouble tracking.
No, I had to go through it multiple times myself, so I appreciate you asking for clarification.
Okay, the port has the opportunity now, and if they're not, and in their view, obligation to cross-examine you. So let me ask the port lawyers, we're close to noon. Do you know, I mean, there was a lot of testimony here. Do you have any idea how long your cross-examination would take? And the question is, and that leads to, should we just continue now till we're over with this witness and then break for lunch, or should we break now and come back, which it may cause problems for the witness? Yeah,
this is Chris Pierce, right? I'm fine moving forward now, and we can break after Mr. Jenkins is done.
Go ahead then.
Good morning. We are still Mr. Jenkins. My name is Chris Pierce Wright. I'm an attorney for the Port of Olympia. I appreciate you being with us here today. I have a few questions for you, and I'm going to start with Exhibit 56, which I will attempt to share, and it's your report. Let me know when you're able to see that.
I can see it. Thank you.
And I'm going to start with your conclusion, which you've put at the top. The first paragraph under that section reads, based on information presented, and then you list the things that you reviewed, and you say, therefore, insufficient basis for issuance of an MD&S. Do you see that?
Yes.
Do you agree that, at least in part, whether there was sufficient basis for an MD&S is a legal question?
Oh, I intended from a noise perspective.
Sure, but whether, I suppose the premise of my question is an MD&S is required by state law, is that right, in certain circumstances?
I can't speak to legal questions.
Right, and so the requirement for an MD&S doesn't exist in the ether. It's a function of Washington state law.
I'm sorry, is there a question? Sorry, was that a statement or was it a question for me?
It's a question. I guess I'm curious whether you agree whether the requirement to issue an MD&S in certain circumstances is a function of state law.
I can't answer that question. It's outside my area of expertise, which is noise.
Okay, so you're not aware of the circumstances in which an MD&S must be issued?
Not legally, no. Only the noise elements of SEPA that may inform an MD&S.
Sure, and so then it's relevant, the legal question about when an MD&S is required, to what must be studied in the context of the development areas that you testified about earlier. Is that right?
I feel that question. I can't fully answer that question. Is it has legal elements that are outside my area of expertise? I'm sorry. I don't feel that I can confidently answer that question. I just don't know when an MD&S is required and when it's not. It's just not my area of expertise.
Sure.
Mr. Pierce Wright, I don't want to cut you off, but I don't know if this will be helpful. I consider his testimony in general that he's suggested that there should have been additional noise or other noise discussion about noise impacts in the checklist and the issuance of the MD&S, but I would not. But I agree with you that the question about whether the MD&S meets the requirements of the state regulations and is adequate is a legal question. So I don't know if that helps you. I don't consider him, but no offense, Mr. Jenkins, I don't consider him an expert on whether it meets the standards or not. He's just saying he thought there should be more in it. Is that, I don't know if that, I don't want to cut you off, but you can keep asking him the questions, but that's the way I take his testimony.
Sure, I appreciate that. And I think just to follow up on that thought, what I'm getting at is embedded in all the testimony about additional analysis should have been done for development areas, for commercial operations is a legal conclusion about when that analysis should be done.
Yeah, I
And that's
understand that distinction. So if you want to follow up on that, go ahead, but
Sure.
Go ahead.
You testified earlier, Mr. Jenkins, about changes to the mix of aircraft operating at the Olympia Regional Airport. Is that right?
Yes,
And your conclusion was there was no analysis done with respect to the addition of commercial passenger service at the airport. Is that right?
not from a noise perspective, no.
Right. And what basis do you have to conclude that the Port of Olympia is proposing to introduce commercial service at the airport?
Because the infrastructure for that commercial service is in the preferred alternative.
And we can talk about the preferred alternative now. I'll share my screen here. I haven't renumbered them, but this is Exhibit 1, Chapter 4. Are you able to see that?
Yes, I can. Thank you.
I'll scroll down to the map of the preferred alternative. Let me know if you cannot see that. And this is what you're talking about.
Well, this is helpful, I think, to understand the spatial orientation of the various developments, but the bulleted list of the various improvement projects, I think, is more helpful.
Okay, I want to focus on this image for a second.
Understood.
Are you familiar with the specificity the FAA requires an airport to identify before a project can move forward?
And no, sir, I'm not.
So I want to ask about this more generally then. You testified earlier about the various development areas identified on this map and concluded that a noise analysis was not conducted for those development areas. Is that fair?
Yes, I specifically pointed out the industrial aviation related developments in the gray areas in the testimony. Those were noise emissions from any potential activities in those areas was not discussed that I could find in the SEPA checklist or in the master plan update.
Are you aware of whether those areas are currently designated as aviation related industrial development areas?
I'm not aware of that.
Are you aware of whether those areas are currently zoned for industrial development?
I'm not sure.
Are you aware of whether the FAA would need to review and approve any industrial development or any other development in the areas identified in this map?
Well, my understanding from a noise perspective, no. My understanding of FAA policy is that only noise from operations, takeoffs, and landings and taxiing would be required for evaluation. I'm not aware of any FAA requirements for hangar work or any sort of other activity that might occur in this map.
With respect to noise?
With respect to noise, that's correct.
Sure, and I guess I'm asking more broadly than that. If the port wanted to construct anything in any of the shaded areas identified here, are you familiar with what level of FAA approval would be required before that could occur?
No, sir, I'm not.
I'm going to scroll down a couple pages here to the conclusion. States that the preferred alternative, about midway through the paragraph, the preferred alternative is directly translated into the drawings contained within the ALP. Do you see that?
Yes, I do.
And for the record, this is page 4-44. I'm going to move over to the airport layout plan, which is chapter 5 of Exhibit 1. Did you review the airport layout plan as part of your preparation for providing your opinions today?
Briefly, I did not spend as much in this chapter as other chapters, but I did review it.
I'm going to scroll down to this map. Do you recognize that map at least?
Yes.
Could you describe have you seen it before? How do you recognize it?
Well, I recognize it because it looks similar to the figure that we were looking at just briefly before.
And are you aware of whether or what approval authority the FAA has with respect to this map?
No, sir, I don't.
Mr. Pierce Wright, is there a page number for that map?
It's sheet 3 of the airport layout plan.
Sorry to interrupt you.
That's all right.
Okay.
Maybe what's the one right before it?
Something's blocking it on my screen. Yeah, you can see in the bottom right, the bottom right-hand corner, it says sheet 3.
Okay.
Sorry for roller coaster. Yeah. I'm going to stop sharing my screen so you don't have to look at that as I'm adjusting. Mr. Jenkins, I'm going to go back briefly to your opinion letter, which is Exhibit 56. And I've scrolled down to page 2. Are you able to see that?
Yes, I can see it. Thank you.
And the bottom of that page, the last paragraph, the second sentence, you state aviation-related and industrial development projects would fall outside of FAA jurisdiction. What's the basis for your conclusion in that sentence?
Well, in my experience, the FAA, from a noise perspective, again, I'm only talking about noise, whether it's a Part 150 study or some other type of planning study, the noise emissions from the airport are specific to takeoffs, landings, and taxiing. They don't include any other sort of activities on site that may occur from, well, this probably isn't the best example for this airport, but baggage handling equipment, things driving around on the tarmac, or activities in hangars, ground run-ups, things like that aren't specific to operations of the airport, takeoffs, landings, taxiing. In my experience, those fall outside of the FAA noise review jurisdiction.
Fair enough. And so what you're familiar with, that sentence isn't intended, or you don't have the basis to conclude that the FAA does not have review authority over development of property on an airport property.
No, sir. I'm not intending to draw any conclusions or make any statements for anything besides